Thank everyone in attendance. We look forward to hearing from today's guest speakers from Doré Rothberg McKay in what should be a very informative session on bankruptcy product prices and how this can affect credit decisions. I'd like to first start off with a couple introductions for our guest speakers. First, Carl Dore. After working for a decade as a petroleum engineer, Carl established a law firm practice more than 30 years ago that focuses on real estate and oil and gas, as well as litigation in those areas. Carl is a frequent speaker and writer on developments in the law that impact business decision makers and entrepreneurs. As a result, the firm routinely helps form new corporations and limited liability companies. Carl's experience in commercial collections and lien preparation for contractors and oil and gas service companies is second to none. Next, we have Zach McKay. Zach joined Doré Rothberg McKay in 2013. He supervises the litigation and bankruptcy practice of the firm, directing the efforts of a team of lawyers and paralegals. Zach has been a lecturer and a teacher for seminars and courses in legal subjects, including defending preferential claims, enforcement of liens, and legal developments in the oil and gas industry. Prior to joining the firm, Zach worked at a bankruptcy firm that specialized in representing Chapter 7 and 11 bankruptcy trustees. His primary area of practice is bankruptcy and business restructuring, with a focus on representing oil and gas industry creditors. And with that, I'd like to hand it over to Carl Dore to get us started.
Carl, are you muted?
Fine. There.
There we go.
Good morning. Yeah, this is welcome to 2020. Are you muted still? I love the introduction because I've been involved with PESA CID for 30 years. And when they tell you hold your questions till the end, I don't know how you people are going to be able to do that. CID is not known for that. But we're going to jump right into it. What we tried to do is what have we learned in this latest round? What's going on in the industry? So we started deciding that we would pick up a case that what is some good things that have come about that you can do as a credit manager in bankruptcies. So I want to start with one that was in the last go round, and it was American Eagle Energy out of Denver.
Oh, Carl, let me share my
pull up those
real
slides.
quick.
While he's doing that, we did have some early questions. Zach and I have each other's questions that would popped up, so we'll be able to go over some of that. I think it's slide 6. There we go. All right. No, back up a couple. Back up one.
There we go.
All right. In the American Eagle Energy bankruptcy was in Denver in 2015. And there are 3 things that came about that exemplifies what we're going to be wanting to talk about on a series of the current cases. It's going to show this case showed the differences in recoveries between an unsecured position and just the general unsecured. Because for some of your CFOs and treasury groups, it's almost like when they come to work for an oilfield services company, they get to be introduced for the first time in their life to the world of unsecured credit. We get to show the importance of filing perfect liens and the importance of banding together in a joint representation. So on this one, those companies that filed liens, we had 2 sources of recovery. The first one was from the debtor. After a big, long series of litigation and efforts, we received 36.6% recovery from American Eagle itself. We had a second basket of recovery, and that was from the non-operating working interest owners who were partners with American Eagle who failed to pay their joint interest billings. That was a second tier of litigation where we sued those people to say that money that you did not pay American Eagle, when you received the notice that we were going to file a lien, we want that money now. So that those funds were not paid to the estate, but rather paid to our ad hoc group that we had a second source of recovery. The total amount that we recovered in the bankruptcy was about 47%, a little over, not quite half, but okay. But the advantage of those people who filed liens and went forward in a group effort was about a 20-to-1 return on the legal investment. So was it worthwhile? We think so. So what we want to do now is move to the next what is going on in a series of current bankruptcies. So Zach is going to pick up Chesapeake.
Great, thanks, Carl. Yeah, and filing liens is going to be a theme amongst this group of new bankruptcies. They're going to mostly set you apart from the unsecureds, not only in the way that Carl was talking about in the litigation aspect, but some of these cases, these debtors file motions to pay critical vendors. And what that is essentially if you are a critical vendor, or these days, if you have lien rights, because they want to avoid liens to get filed, you are in a better position to get some of that money right off the bat and be able to step out of the case. So Chesapeake is one where the judge allowed the debtor to pay up to $350 million to trade creditors that were owed pre-petition. Now, these agreements usually come with a little bit of negotiating. You're not guaranteed to get paid 100% on the dollar. Chesapeake was pretty good. I think the average payout for their trade creditors was 80% for the pre-petition amount, which is a really good offer, considering they don't have to pay that much. And we're going to provide you with an example of one going on right now. Next, they're providing way lower than that. So the 80% offers represented a pretty good deal for most Chesapeake critical vendors or lien claimants. One thing I'd like to go over is how can the debtor pay a specific creditor and not pay another creditor, even though they're similarly situated? This is the idea of the critical vendor, and that's the motion that gets filed on the very first day of the case. In this case, they didn't use the words critical vendor; they used the words lien claimants. So it's just another way of picking who they need going forward, what relationship they want to maintain, and getting those folks paid off. Okay, so speaking of a little bit more of a hardball approach, Fieldwood is going on right now. This is a Chapter 22 case, which is what we call a second Chapter 11. So it's an 11 followed by an 11. This is one that another critical vendor motion got filed. We call it a quasi-critical vendor because they don't use those words. I think in this one they used E&P operating expenses. And this debtor got authority to pay up to $60 million on the interim, and I think it was like $200 million on the final version of this order that they got. Now, what's different about this case from Chesapeake is this company is taking a much more stringent approach on handing that money out. They're offering initially to most folks about 20% to 30% on the dollar. And so they're asking their vendors to forego filing liens, take the 30% prepayment offer, and in exchange for that, you're going to have to continue to provide good payment terms, good credit limits, good payment, good pricing discounts, and all of that moving forward. That's the thing that you provide in exchange for getting that money. The difference is in this case, you're only getting 20 to 30%. There are a few that got more than that, but very few. And this case also it represents an example of what the industry is going through right now in the sale process. This case got filed with the intent to sell all of the assets. They went through a sale process and they really didn't get any qualifying bids. So now they're having to pivot in the late stages to a reorganization. And we don't know what that's going to look like yet because the plan hasn't gotten filed. But and these are all offshore properties for Fieldwood. So that's an interesting twist on this particular case.
Before you go to that, let me add that in both of those cases, despite the fact that the court allowed the interim order to pay money, they both started with really horrible lowball offers. Chesapeake, there was a lot more discussion between all the trades, all the service companies, to say, we're not going to accept 50 cents on the dollar. We're not going to accept 60 cents on the dollar. And the negotiations began to run into the fact that there's third-party claims buyers who were willing to pay, I think it was 82 cents on the dollar. So the service companies were able to go back to, why would I settle, Chesapeake, with you for 50 cents when I can sell my claim for 82 cents? And that allowed some negotiations to go your way a whole lot easier.
Mm-hmm. Okay, now this next one is MDC. I'm sure most of you have heard about this one. This one was filed in Delaware, unfortunately. And Carl added this. He was involved in a lot of pre-bankruptcy dealings with Mark Siffin, as I'm sure several of you are. It resulted in a lot of delays and a lot of miscommunication. We didn't know what was coming. We said we were going to get payments, and then all of a sudden, this bankruptcy gets filed. Total trade creditor claims in this one upwards of $200 million. The Delaware U.S. trustee did not appoint an unsecured creditor committee in this case because she felt that most of the claimants were lien creditors, and therefore they weren't unsecured. We have fought time and time again against that way of thinking, but in this case it failed, and it's really showing because there's no watchdog in this case. There is a group of trade creditors that is banded together in a sort of ad hoc group, but the problem is those trade creditors are having to pay attorney fees for that, whereas if a UCC was appointed in this case, the debtor has to pay those fees. So it's really not a very well-ran case. We don't know what's happening in this case yet either. We don't think a sale has been effective. There was supposed to be a sale hearing this week, and all of a sudden it got canceled out of the blue. So this one's a little bit up in the air as well. We're probably going to see another pivot to a reorg. Now in this one, again, to continue with the theme of what happens when everyone files liens, this debtor is having to pay the price for letting everyone file liens. There are over 50 lien adversaries filed by the debtor in this case. And so they're having to fight all of these lien claimants at the same time. There's infighting in between the mineral lien creditor groups. And right now we're dealing with a very complicated effort to mediate towards a global resolution. Judge Sanchi has appointed retired Judge Felsenthal from Texas to mediate this effort. And it's going just about how you think it would go. It's very complicated. There are 100,000 opinions that everyone has, and I don't want to be pessimistic, but there are a lot of hurdles before we achieve a global resolution and a 60 person mediation, if you will. So that's what's going on in this case. And the liens, if they just were taken care of early on, the debtor could have avoided all of this. I'm going to continue with that theme. Here in Southlands, it was a little different. There were 50 lien creditor lawsuits filed by the lien holders pursuant to the lien procedures that got set in place. And in this case, the debtor, instead of fighting all 50, an interesting tactic, they chose one creditor. I believe it was Halliburton, and that was Halliburton was the biggest trade creditor in this case. And they chose one creditor to attack the lien law against. So it creates an interesting situation where Halliburton is having to defend the brunt of the attack for all these different legal avenues to protect against their Wyoming liens. Whereas the other 49 creditors are having to sit on the sidelines and watch it happen. So that's an interesting caveat that's going on in this case, where the debtor chose a test case to attack. I think all of these debtors are trying to find the best way to do it, and that's why you're seeing so many different ways to attack these liens. I don't think anyone's found a good way to do it yet, but this is certainly an interesting tactic. Okay. Extraction is one where liens turned out to be very important. This was another Delaware case. There were, 141 million in trade claims. And ultimately, the plan of reorganization ended up getting filed, and it's currently drafted to pay all trade claims in full. Now, the problem was in the initial draft of the plan, trade claims was defined as just about how you would expect, vendors like you guys. But later on, after a bunch of objections got filed to the plan, they filed an amended plan that amended the definition of trade claim to say only those of you that could have filed liens were considered a trade claim, which is an interesting definition of trade claim. So that's where we are in that case. That plan is currently moving forward, and we're going to see if that gets finalized. And we do think that there are some serious preference exposure. There is some serious preference exposure out there for this case, like a lot of these cases, and we're going to get into what preferences are and certain of the defenses in the second half of the presentation. And we wanted to throw in the idea of a purchase money security interest. I think Carl wanted to talk on that.
So we have talked about this. I have talked about this for years, but never really called it the purchase money security interest. Some of you have heard it. It's the opportunity and the option to file a UCC-1 to claim a security interest. But here's the deal. In the oil and gas sector, it's hardly ever done. I hear it's too much trouble. I'm too busy. It's going to interfere with my customer relationship. But this is about your only option when the exploration production company, the E&P company, has a blanket security interest in all its assets to its senior lender. How can you do and what can you do to have priority over that first lien position? This is it. And it's simple. It's a two-party transaction. It's between you as the supplier or seller of goods. It's only your goods, equipment, stuff like that, not services, but it can retain a security interest for the purchase price of those items. So if you have frac sand, cement, a piece of equipment, a wellhead, you have an option to do this. You have to have a signed agreement for the existence of that purchase money security interest, and it has to have authorization for you to file the UCC-1. It's a financing statement. We have language. You can include it in your MSAs. You can include it in your terms and conditions, but the customer has to sign. There's two key requirements. You, as the party claiming to be secured, gives new value, and that new value is this equipment, and you want a secured position for that collateral. That's it. It has some very tight deadlines. Those deadlines are the perfection period, and you have to file a financing statement within 20 days. The financing statement is the UCC-1. It's filed with the Secretary of State of the state that you're going to be doing work in. In Texas, the filing fee is horrendously expensive. $5. $5, you can have a position to be ahead of those senior lenders. I hope you guys ask some questions about this one in our breakout time. But it's even shorter if your goods are for inventory. So we have a client that furnishes perforating gun bodies, just the shell. To get a security interest in that, you have to file before delivery, before possession goes to the customer. But that's it. That's all you have to do. The paragraph phrase that we include, that we recommend inclusion, it can be part of your MSA, part of your terms and conditions. When they sign the credit application, that could be it. That's all you need to do.
Okay.
That's it.
So, Carl, why don't you go over the bottom line?
Sure. Bottom line here is in this bankruptcy cycle is pretty much the similar in the 2010 cycle, the 2015, 2016 cycle, and it's now. Consider serving on an unsecured creditor committee. A lot of companies don't want to do that. I'm too busy. It's too much trouble. Look, it's these days it's all telephonically. Even the selection of attorneys to represent the entirety of the also unsecureds is done by video and Zoom and whatever. If there's not an unsecured committee, consider an ad hoc group. We did that in American Eagle Energy. It's going on in MDC. If you're doing an involuntary action, that's a little more rare, but considering doing that and filing involuntary just to lock in venue. Recent case was, I think it was White Star. Weatherly. It was Weatherly that the venue was locked in for Oklahoma as opposed to allowing what the debtor wanted to do was file in Delaware. Wasn't it Weatherly?
It was White Star, yeah.
White Star, okay. Consider always filing perfect liens and then exploit the fact whether or not the assignments and deeds of trusts have problems. A case a few years back found that the senior lender forgot to file their lien in an entire county. That particular one was Webb County. So every mineral lien had senior priority. And then immediately evaluate preference exposure and determine, do you have some defenses? Some of you may never have even heard of preference claims. So that's what we're going to go into next, to go over what is a preference claim,
right,
and what does it mean to us.
Right, that's a perfect transition. And this is the part of the presentation that's really going to want to make you throw up. It's the preference section. What happens when you receive a payment in that 90-day preference window, which is the 90 days just prior to a company filing bankruptcy? So the idea, if you've never had to deal with it before, it seems pretty crazy. The idea that you performed work that was good and not disputed, and you did your job and got paid for that work. So where does the concept come from? The Bankruptcy Code essentially presumes that if you receive the payment in that 90 days, that you are preferred over other similarly situated creditors. And so, the idea is we don't want the creditors to race to the debtor to get paid. We don't want to push them into bankruptcy. We don't want to produce favoritism by the debtors, which of course happens. If you're about to file bankruptcy, you want to take care of your most trusted vendor. You want to take care of those relationships that you really value. And if one of those relationships was you guys, you just might have received the preference payment. Ultimately, Congress decided to avoid the inequality of distribution. This was a law that they put into place. The idea is to take the money back from you and put it back into the pool of distribution, put it back into the pie so it can all get sliced up evenly. Now, what we know happens is a lot of it gets eaten up with attorney fees. So is this successful? I don't know if this law is successful in doing what it tends to do, but it's certainly, it makes sure that no one gets taken advantage of. I suppose you could argue that. But so what are the elements? I'm not going to spend a lot of time on this because this is all legal jargon, but this is the complicated version of what a preference payment is. A transfer of an interest in the debtor and property, which basically means, okay, you received the payment. To or for the benefit of a creditor. There are some weird instances where you could argue that you aren't a creditor. But otherwise, we don't even worry about that line. The third element is on account of an antecedent debt, which means, what does antecedent mean? It means something that you have already done. So a good or service that you have already provided. In other words, a preference payment is not COD. It's never a prepayment. If you're asking for a prepayment for goods that you are about to do, that's not a preference exposure. It doesn't meet that element. Made while the debtor is insolvent. You could forget that because the debtor is presumed insolvent for the 90 days. So the most important of the next part is made within the 90 days before the petition date. Was it a payment made within 90 days before the petition date? If so, you have some exposure. And then the last element is it enabled the creditor to receive more than it would have received in a Chapter 7. And that begins a complicated analysis that's not really the focus of the presentation today, but it does give us some ways to wiggle out of preference exposure on the defense end that we'll get into in a minute. So basically, what am I talking about here? You received a payment for goods or services that you've already provided, which means not a prepayment, not COD, in the 90 days prior to your customer filing bankruptcy. That's what it is. For the purposes of you recognizing what a preference payment is, that's what you have to remember. 90 days, and you already did the work, okay? Now, if the trustee or the debtor can prove up all those elements, you can now prove up defenses, certain defenses. There are three of the ones that we use most commonly. The big one is ordinary course of business. Yes, maybe you did receive this money in the 90 days, and it did meet all those elements, but the result of that payment fits squarely into the ordinary course of business that you and that debtor have always done. Okay. The next one is contemporaneous exchange, which is sort of like you're selling something right then and there. You're intending it to be a contemporaneous exchange. And we're going to go over these in more detail in the next slides. And then the third one is a subsequent new value. And the idea behind that one is you receive the payment and then you subsequently provide a new value to that debtor. And that's a dollar for dollar discount that you provided as a defense. Okay, so let's talk about ordinary course of business. This is the big one, really. This is where we spend most of our time defending these things. In 2005, there was a bankruptcy code amendment which added some beef to this defense. Previously, before that amendment, you had to prove up two things. And, oh, lost it. Right here, these two. You had to prove that the payment was in the ordinary course of the business between the parties, meaning you and the debtor. And you used to say, and you had to prove that it was ordinary according to ordinary business terms, which is an industry analysis. So after 2005, they changed this and to an or. So you could either prove A or you could prove B, which is a great help to us because now all we have to do, we don't have to worry about the industry, what's going on in the industry if we don't want to. We just prove that it was ordinary between you and the debtor. Separately, we could forget what's going on between you and the debtor. We could just say, hey, regardless of how weird it looks between us and the debtor, it was just about what was going on in the industry at the time. And during a downturn, you could stretch that defense out quite a bit because you could say, yeah, we got paid 170 days after invoice, but that's what's going on in the industry right now. We've used that argument several times to different levels of success. So let's focus on this first part. What's going on between you and the debtor? What do we look at? Days to pay, most importantly. How long did it take the debtor to pay you in that preference period? And we compare it to how long it took the debtor to pay you previously. We look at the size of the payments. Did you receive some crazy big $2 million payment when historically you only received a couple $1,000 payments? That's something that might push you out of the realm of ordinary. Similar form of payment. This is interesting too. Sometimes it's forgotten. Did you used to receive checks every week and then all of a sudden you received a wire? That's going to clue the judge off and say, something's not ordinary about this. And then finally, my favorite is the payment was a result of a coercion tactic by you. Were you sending mean demand letters? Were you threatening to file liens? Did you push them to pay you? That's certainly something the judge is going to look at and say, well, this is not ordinary because you were pushing them around. And again, this B, the second part, forgets all of these factors. And it just says, forget all that. What's going on in the industry? And those are the two different versions of that defense. And we spent a little extra time on that because that's the one that's so important. Let me take you through what an example looks like. This is an old case, GMX Resources, a payment history, simple payment history from old to new, okay, old to new. And you look at the days to pay. This is only looking at days to pay. 73, a couple 47s, 36s. And in the preference period, we have a 50, 56, 54, 64. So pretty similar here. We argued that, listen, they're not exact. They're never going to be exact, but they're pretty within the realm of ordinary. If you look at it in a visual, I think that's pretty clear as well. I mean, all of these payments fit squarely, at least what I argued, within what was ordinary here. There were some gaps where there weren't payments made, and that's how the trustee eventually, stretched some settlement out of us. But this is the kind of idea that we're going for, okay? I see we have 5 minutes until we start the breakout, so I'll push through here. So that's the ordinary course of business, and I'm glad we got through that because that's the most important one. Contemporaneous exchange for new value is another one. This is when you received a payment, but you provided new value contemporaneously, and you intended for it to be contemporaneous. An example of that is cash on delivery. A lot of this is more relevant with goods, this contemporaneous exchange, okay? And then the third big one is new value. So what happens when you provide subsequent new value? This is only focused on the 90-day preference period. If you received a payment and then you went out and worked for the debtor after you received that payment, the bankruptcy code looks at it and says, look, maybe you were preferred to get that payment, but then you went out there. You tried to help this debtor, and you're going to get rewarded for that because you went back out there. And if you spent money adding value to this bankruptcy estate, we're going to subtract on a dollar-by-dollar basis any preference exposure that you had. Okay, so this is important only if you were working with the debtor right up until they filed. This is something we always look at as well. So just some general practice tips. Watch for signs that the customer is approaching a financial distress level. You guys are probably more clued into this than anyone. One thing you can do is require an immediate payment. Create a prepayment structure. I know that's almost impossible these days, but that is the only way for you to be preference proof. If you start requiring prepayments, remember, they cannot meet one of those elements, which is the antecedent debt element. Any prepayment can never be a preference. So if that's something you have to do, avoid this preference exposure, you have to get prepayments. When you receive a payment, the general rule is that payment is applied to the oldest invoice. There are some competing theories on this. Some say you should consider applying it to the most current invoice in order to try and fit yourself into the ordinary course of business defense. Personally, I think you should just continue on in your practices, because if your ordinary course of business defense is going to get ruined, it's probably not going to be by how you applied the invoice. And if the trustee gets wind of you applying the invoice in a different way, that's just more ammunition for them to say it wasn't ordinary. Okay. Ask for a deposit for future services. That is really repetitive of the prepayment comment. Something else you could do, just general protection tactics, ask for a letter of credit, ask for a corporate guarantee. Carl, you want to take this last slide before we break out?
Sure. This is one that we run into often. And what happens during the preference claim period, and you receive this letter from an attorney saying, you received money and I want it back. And you get this letter that says, but if you pay us 80 cents on the dollar, we'll call it good. Our recommendation is don't take that offer. Almost always, these are law firms that work on a contingent fee basis. I pretty much figure that those are parasites on society. I hate those guys.
We have done it before, though. Not going to lie.
Yeah, exactly right. So don't take that first 80% offer. Instead, look at what defenses you might be. And you might have. You'd be surprised. Zach gave a pretty simple chart from the GMC case, GMX case, and but sometimes the effort to show what is ordinary course of conduct might be, how did they pay us in the last 4.8 years, or the 3.7 years, or the 2.9? We don't know what it is to show the biggest discrepancy of, instead of, if they're paying us 45 to 55 days, it might be 39 to 73, or even a lot more. And so the more you can do that. And then, because what we do is we build an Excel spreadsheet using a statistical analysis to find a mean, a median, how best to demonstrate that this claim amount, maybe there's only 10% that we cannot show a defense to. So negotiate. Very rarely do they go to trial. However, we say that, and we have had a couple of them go to trial, but those are usually big claims, big amounts. They're looking for a couple $1 million. Well, the exposure is so high that you're going to be willing to do it. Many times, if you're the last man standing, everybody else has gone out there. These law firms, they're looking for the easy pickings, and they're going to be jumping those. So if you're the last one, those law firms are going to be wanting to settle, be done with it, And so you can, at that point, usually end up with a better negotiation strategy. That's all I had on that part.
Right.